The problem which this country was facing was that those who were criminals or at least facing criminal allegations used to either flee the country or they used to go somewhere hiding, and the courts were helpless because there was no provision and they were declared absconders. For the first time now the Indian law provides that after a person who evades the process of law and is declared by the court to be an absconder, the court can proceed against him and even pass a sentence of conviction in his absence. This is a landmark change, and that was the moment a person is arrested, he would admit himself into the hospital. There were some hospitals, let us face it, who were ready to oblige him by saying that he is suffering from a very severe disease and therefore there cannot be any investigation, interrogation at this stage. Friends, in history of any nation, a time comes where you have to shift from old to new. Before independence, we were governed by the laws which were meant to rule us and not to give us the rule of law. We inherited that law and series of other laws in 1947, and the country was craving, country was demanding and expecting that now there would be a Indianized version which from the regime of punishment to the regime of justice, there would be a shift. But every revolution needs a particular time where several things comes together. We have a very vibrant and efficient decision maker as a Prime Minister. We have a very bold and intelligent Home Minister, a very vibrant Law Minister, and above all, the will of the people to make this change which was ready to happen since 70 plus years. It is that change which the Parliament brought and shifted the regime from punishment of those who are ruled to the justice of those who are citizens of India, who have given to themselves the Constitution of India. Friends, there are several new aspects which, of course, the very, very learned persons who are participating in the panel discussion would highlight. But to me, I would wish to highlight 2 or 3 very important changes in the regime, in the legislation, and in the way India thinks in the present era. I would like to highlight them. First, now we are in the digital era under the very able leadership of the Honorable Chief Justice of India, the judiciary, the judicial infrastructure, and even lawyers are shifting to the digitization and digital mode of dispensation of justice. For the first time, now the digital testimony of a witness is accepted to be a valid testimony. So now there is no necessity of people traveling all along from various parts of the country or the state to depose. This is a revolutionary change which was waiting to happen, waiting for a committed government who is committed to reform to bring it as a part of its legislation. Now, electronic mode is permissible in all criminal proceedings. Second, the problem which this country was facing was that those who were criminals or at least facing criminal allegations used to either flee the country or they used to go somewhere hiding, and the courts were helpless because there was no provision and they were declared absconders. For the first time now, the Indian law provides that after a person who evades the process of law and is declared by the court to be an absconder, the court can proceed against him and even pass a sentence of conviction in his absence. This is a landmark change which we as a nation could achieve. People were facing one more difficulty, and this is where the role of the parliament comes. Parliament ultimately, across party lines, consists of representatives of the people, and the representatives have the pulse of the people. They know the day-to-day problems the people are facing. One of the main problems a common man was facing was a crime is committed, either with me or I have been witnessing a crime, or I came to know about a crime and I want to get it registered. When I go to a police station, the police station would say, this is not within my jurisdiction, I will not register an FIR. And under the old law, that was permissible defense for the police. For the first time, by a statutory mechanism, there is a provision of a mandatory requirement of what is called zero FIR, meaning thereby, even if I go to a nearest police station having no jurisdiction, it is their responsibility to register a zero FIR and transfer it to a police station having the jurisdiction. Now, a common man of this country will not be told by any police station that we have no jurisdiction. They will have to register the FIR. One more problem which every criminal lawyer practicing on prosecution side or on the defense side or others who are connected with the field of law would know. The problem was the various devices which were found by some cunning litigants who were facing criminal investigation. And that was, the moment a person is arrested, he would admit himself into the hospital. There were some hospitals, let us face it, who were ready to oblige him by saying that he is suffering from a very severe disease and therefore there cannot be any investigation, interrogation at this stage. And all of you are aware, under the provisions of the CRPC as it stood then, the first 15 days were crucial. If somehow an accused can pass first 15 days, the investigating agency would lose its right of investigation completely. This was being misused in most of the times, especially by those who are facing criminal charges and have the wherewithals, financial and otherwise. Now the new law provides that while retaining substantially the period of judicial custody, now that 15 days period is segregated. It can be used within 60 days or 90 days as the case may be, depending upon the nature of the allegation made against him, and it can be in installments also. This is not anti-people, this is anti-criminal who is seeking to avoid or evade the course of law. This would not affect a law-abiding citizen. There are several digital reformative measures which are taken in this law. I am not going into the merits of those, but I must say that the digitization as a concept for being implemented in the delivery of justice, in the dispensation of justice, is inspired almost completely by Dr. Justice Chandrachud, who is the karta of our larger judicial and legal HUF. Friends, I thank the ministry to allow me to be here and share some of my thoughts. And I, as a citizen of this nation, thank the Honorable Prime Minister and the Honorable Home Minister to take a call maybe a little later, because they could take a call when they get the chance. And On the first available opportunity, they took this as an opportunity to reform, because continuing status quo is always an easy option. Changing status quo requires courage and conviction. Thank you so much.